Does affirmative action violate the 14th Amendment of the U.S. Constitution? Well, before we can get to what the Supreme Court has said about this, and that has changed over time, we first need to understand the idea of strict scrutiny. So strict scrutiny is a test that the Supreme Court applies to any law that either deals with a fundamental right, think religion or speech, or a suspect classification, race. In other words, if any law is going to treat people differently on the basis of race, it needs to be, one, a compelling government interest, really, really important, and two, narrowly tailored, or in other words, it needs to further that important goal in the least restrictive way possible. Affirmative action has to pass the strict scrutiny test, and the Supreme Court's opinion on whether affirmative action does pass that test has changed over time. So our first example of this is Regents of the University of California versus Bakke, a 1978 case. And it's messy. There's 6 different opinions from the court. But basically what they find is, okay, diversity is a compelling government interest. But you can't use racial quotas. That's not narrowly tailored. But you can use race as kind of a bonus factor. And interestingly, they actually point to Harvard College, that will be important later, as an example of a good affirmative action program. Grutter versus Bollinger, a 2003 case, will see the Supreme Court doubling down on this. So the University of Michigan Law School seeks to admit a, quote, critical mass of minority students, again, arguing that diversity is a compelling interest for a state school. And the Supreme Court is going to say, yeah, you're good to go, because diversity is a compelling government interest, and this is narrowly tailored. You have individual review of applications. This isn't exclusively about race. And crucially, this has an end date. It's seeking to remedy a past wrong. It's not just going to continue forever. Now, the dissent is going to jump in and be really, really important later and say, wait a second, this is just a racial quota pretending to not be a racial quota. And we've already said racial quotas are unconstitutional. And also, what on earth does a, quote, critical mass of minority students mean? And also, an unspecified end date is the same thing as no end date. And finally, Clarence Thomas will say, you can't have any distinction in admission on the basis of race. Those dissents will matter a lot in 2023 when the court will decide Students for Fair Admissions versus Harvard. So the court is going to rule that affirmative action violates the 14th Amendment. Harvard's system does not pass the strict scrutiny test. There is no compelling government interest that is demonstrated in any kind of measurable way. Instead, you are relying on racial stereotypes, and there's no specified end date. So yes, race can be taken into account when describing the impact it's had on a student's life and how that's helped them to develop certain characteristics or abilities that are unique to them that they can contribute to the university. But that's it. So which Supreme Court is right? The Supreme Court of Grutter and Bakke, or the Supreme Court of Students for Fair Admissions versus Harvard?